Awesome. Welcome to Show 4 of the Cyber Incision live stream for the CISSP certification, where we're going to be digging into each and every domain, discussing the topics that are relevant, answering any questions you have, and then providing real-world examples, which is why I'm so excited for tonight's show. For those of you who don't know us personally, my name is Joel Bork. I'm your host here at the Cyber Incision live stream, and I am joined by my co-host, account executive over at Uzado, Brandon Krieger. Thanks so much for co-hosting with this for me.
Oh, thanks so much, Joel. This is amazing. Tonight, we're going to have an amazing show with Gourav and talk about a lot of legal stuff.
Yeah, it's fun. So once again, he's breaking into who our guest is already, but joined with us tonight is a very special guest. This gentleman has his CISSP. He also has his CISA, and he spent 7 years as a QSA that helped start, now check this out, the 15th QSA company in the world for PCI. Now, he's also a barred attorney in the state of Florida and is a practicing cybersecurity attorney when he wants to be. It's a pleasure to have you. Thank you so much for being here, Gourav.
Oh, thank you, and I'm pleased to be here and get to share some experiences with you guys. You make me sound really great on paper, so hopefully I'll live up to some of those expectations.
Well, you got the beard to be great on a live stream, so I appreciate you for being here. Now, for those of you who are hopping in, please, I've posted Gourav's LinkedIn profile here in the chat on LinkedIn, so you should be able to see that on the live stream. Please, just real quick, before we kick off, click that link, add him as a connection, because he's an excellent resource, especially if you need a cybersecurity advisor when it comes to legal. So please do that, and we will kick off. Yeah.
Awesome.
Cool. And I saw you posted in the chat. Can you hear us okay? If somebody's there, give us a thumbs up, throw something in the chat real quick that you can hear us.
Yeah, I just want to check in because I know sometimes we a couple episodes, episode 1 and 2, we had a little problems with audio. So just want to make sure we're coming through for everyone and everyone can hear us fine.
Yep, absolutely. And I don't know what you're talking about. I've never had problems with audio ever.
Watch, Austin, you see someone post a link from the last episode.
I know, right?
Screenshot you going like this.
No. Well, cool. Well, let's get into it. We can wait for them to get started here shortly. But we want to jump in. We got a lot of stuff. So we'll do a quick recap on last show before we get digging into the 2 minutes. We'll do a 2-minute recap before we jump into our actual content. Sean, welcome this week. He says it sounds great. Timothy Lesnick says, yes, we can hear you. So we're up and running and off to the races. Brandon, kick us off with that recap from last week.
So last week, we covered a lot of information, change control management, data classification. We looked at methods of enterprise for government. Then we dug into different organizational roles, senior managed security professionals, data ownership, data custodians, users, and auditors, as well as we covered some legal stuff as well. We briefly covered over that, but today we're going to go really deep dive into it just to make sure we've covered all that aspect for anyone that's studying it. And then we have Gourav here to clarify how it really works in the real world.
Awesome. Yeah. Now, real quick before we get started, and I think Gourav might have a comment or two on this, but the exam warning for this. Now, while we are preparing a group of people here for the CISSP certification, this is not just for those going to prepare for this certification. We're going to be providing quality content that you guys can take with you. And today's is specifically how the law impacts cybersecurity. So for those of you looking to study for your CISSP, your exam warning is you are not expected to know the law as well as a lawyer, but we are expected to know when to call Gourav or a lawyer.
Exactly. Yeah. And also just, make sure that a lot of this stuff is common sense, and don't get tripped up on the fact that there are different laws in different jurisdictions. So not one size fits all for everything. But I will tell you, they're going to be looking at what the general rules are, not necessarily the exceptions. And they're really just trying to make sure that you understand what a normal cybersecurity professional would understand with regard to the law. And like you said, when to call an attorney because it's above or beyond the scope of what you want to make a decision on.
Yeah, agreed. And ethics, right? I mean, it comes back to on the certification and in life in general, do the right thing. And that's what it comes back to. So let's go ahead and jump in. You gentlemen ready?
Oh, I'm ready.
All right, let's do it. So today we're starting with criminal, civil, and administrative law. So last time we touched on the 3 major types of law, and we're going to jump into common law. So common law is the most represented type of legal system on the exam, so it's going to be our primary focus for today's session. Now, within common law, there's various branches of laws. This includes criminal, civil, and administrative law. Now, criminal law is the one we're going to start with, but this pertains to the laws where a victim can be seen as society itself. So while it may seem weird to consider society the victim when an individual is murdered, the goal of criminal law is to promote and maintain an orderly and law-abiding citizenry, right? So when you were watching any of these, CSI Miami's, a lot of this is criminal law. Am I right, Gourav?
Absolutely.
Yeah. So the goal of criminal law is to deter crime and punish offenders. Now, in cybersecurity, I mean, are we seeing a lot of criminal law? Yeah, we are. I think.
Yeah, I mean,
go ahead.
Just the other day, there was a 17-year-old that got arrested for his Twitter hack, and he was in Tampa, Florida, and he was behind a pretty good sized Twitter hack, and he violated some federal laws. And so, yeah, there are some criminal penalties for some of the actions you take on your computer.
Yeah, and I know some of the more recent indictments for Chinese actors as well. It wasn't just against somebody hacking for their government, but there were also criminal indictments as well because they were hacking for their own gain as well. So pretty unique indictments when it came to that side of things.
From a practical standpoint, that's also one of the reasons that we like to get, especially people like you, Joel, that are really great at getting into systems. You want to make sure you get that signed document from your client prior to going and getting into their systems, because you want to make sure that you have the appropriate authority to do that. And you're not going to be in a position where somebody points back and says, "Oh, he got into our systems and he didn't have authority." And who's Joel? We don't know. Just because it crashed, we don't know him anymore. We want to make sure that we look at the legal criminal aspects of it as well.
Yeah, get that rules of engagement signed by the right parties involved every single time. Now, real quick, bringing it back to our audience here today, it looks like we have a number of people. Thank you guys all for joining us here today. If you have a second, please post in the chat where you're tuning in from. Give us a city and state, or just a state in general. Give us a general idea of where our listeners are from today. We're excited to have you guys. Thank you for tuning in. Now, Brandon, I'm going to kick it over to you. So we touched on criminal law. There's definitely a lot going on and that definitely pertains to the cybersecurity community. Go ahead and jump into civil law for us.
Okay, so let's cover civil law. In addition to civil law being a major legal system in the world, it also serves as a type of law within the common law legal system. Civil law is also known as tort law, which deals with injury loosely defined. So any lawsuit that is seeking or suing for damages, that's a civil law. The focus of criminal law is punishment and deterrence. Civil law focuses on compensation for the victim. So let me ask you, Gourav, like when do we look at civil law in these situations? So like if we're looking at protecting someone's data, for example, when can civil law take effect on a company?
So criminal law, you have a bad actor. Let's say Joel gets disgruntled. He goes after some company data, and we have a bad actor. And in that situation, there's going to be a criminal punishment for Joel or whoever the bad actor is. Now you turn around and you say, okay, well, what about the people who actually had the data in the system that was compromised? If Twitter or one of these other companies is the custodian of your data, they have your PII, your personally identifiable information, or other types of protected information. Now you turn around and say, well, did the company do a good enough job of protecting that info? If they didn't, if they had, and we'll get into this later in the conversation, did they have a duty to protect your information, and did they violate that duty? And if they did, you may be entitled to compensation. And so that is the crux of the seminal of the civil law. And there are some seminal cases on that basically come out and say, look, you have a duty of care to make sure that the data that you have in your custody is protected adequately. And that's pretty much across the world, and the laws are becoming more and more prescriptive on those topics.
Now, we did cover that earlier, and you weren't here, Gourav, but we talked about due care and due diligence, and it seems like that's something that's important to really think about when you're looking at your security protocols and implementing security practices, is your due care and due diligence for this.
Yeah, absolutely. I mean, you need to make sure that when you take custody of someone's data, you have certain duties that are going to come along with that. I mean, if if you babysit someone's child, if you house sit for them, if you borrow a tool from them, you have a certain duty to maintain the standards for whatever it is that's in your care. And if you don't do that, there's certain implied duties. If you don't maintain those duties, then you're going to turn around and open yourself up to civil liability, which is going to be some sort of damages. And depending on the degree to which you may be negligent or grossly negligent, the damages may have multipliers on them, such as punitive damages. And that's really just basically saying you did something that's really egregious and not just within the standard scope of being negligent. You were very negligent.
Okay. I mean, Joel and I were kind of writing our show notes for this, and one of the examples that we brought up was O.J. Simpson, when the murder trial, in which Mr. Simpson was acquitted in a criminal court for the murder of his wife, Nicole Brown, and Ronald Goodman, but later found liable in a civil court proceeding for causing the wrongful death of Mr. Goldman. So this is kind of a really real-life situation where you can kind of see it in action, where the criminal case, was dismissed, but then all of a sudden there's a civil case after.
Yeah, so in most instances, at least in the U.S. And most North America, there is a different standard for culpability for criminal law than there is for civil law. So an example would be with the O.J. Simpson case, we may need to have a unanimous verdict, a jury of people that all come to the same conclusion to say O.J. did in fact commit this crime. The standard for civil law is much lower. So in a case or suit for damages, it might be what's called the preponderance of the evidence. What that means is basically if you have the majority of the vote, or if it just slightly tips the scale beyond 51%, then there may be, in another legal term, contributory negligence. What that means is that they contributed to this loss. Their negligence contributed to the loss. It may not be entirely their fault. Like in a criminal case, it's either entirely their fault or it's not sufficient to make sure that they are culpable for that crime. Civil's not as strict.
That's so interesting, right? Because just tipping that tides where you could be liable, right? And there is that gray area. I think that's a great example of the difference between the criminal and the civil law. I mean, it's stuck in my head. I'll never be able to forget it now. So thank you, Gourav.
You're welcome.
No, he's going to go back to work tomorrow, and then he's going to tell people, I know this inside and out.
I got this. Now, if you guys are listening, please jump in the comments. Any cases that have come up recently that in regards to criminal, civil that you've heard, throw it in the text, throw it in the chat. It adds context to the show. So please feel free to jump in there. All right.
Yeah.
Cool.
If you guys have any questions too, throw them in there.
Yeah, absolutely. I mean, while we have the professional on the line, please throw out some questions. If we can answer them here, we definitely will try. If not, we'll follow up after the show and after we Google it for you. So, cool. Well, let's go ahead and jump into administrative law. I appreciate the giggle, Gourav. But so administrative law is the next type of law. And this is enacted by the executive branch, right? So this is deriving from the office of the president. So you guys have probably heard in the news, there's lots of administrative, what are they called? Administrative, not ordinances. What are they called, Gourav?
Executive orders.
What was that?
Executive orders.
Executive orders. Thank you. Right. So when the president signs an executive order into law, it's mandated compliance measures that they have the capability to enforce. Now, the executive branch can also create administrative law without requiring input from the legislative branch, but the law must still operate within the confines of civil and criminal code and can still come under scrutiny by the judicial branch. So correct me if I'm wrong, but after he does an executive order, then the judicial branch can actually overturn that order.
Absolutely. And the judicial branch can overturn a law that's enacted by, you've got three branches of government in the U.S. They can overturn a law that's created by Congress. They can overturn an action or an executive order that's created by the executive branch. So either legislative or executive can be overturned by the judicial branch. And one thing that's important to know about the administrative law side of things is one of the key purposes for, and people may ask, you say, well, why would we pass this off to the executive branch? Why wouldn't we just legislate everything, right? Well, there's a certain degree to which Obviously, the legislature can't keep up with the amount of debate and conversation that needs to happen around a particular topic. There's just too many topics and there's too much detail for them to legislate tomes and tomes of information. So what they'll do is they'll say, hey, here's legislative intent. This is what we want you to do. We want you in the FAA, let's say FAA, I'm a pilot also, so I love flying. And if the FAA wants to have safe operating procedures for airplanes, you're not going to have the senators on the Senate floor saying they're arguing about whether or not the distance between airplanes should be 1 mile or 2 miles or 3 miles. They're just going to say, you need to operate the airspace safely. The executive branch is going to hire a bunch of people, staff up the administration, and say, let's hire experts. These experts are going to come in and determine whether it should be 1 mile, 2 miles, or 3 miles. And so that's where you have an administrative law that comes about from an overall legislation that maybe creates the FAA and defines its general purpose. And the idea is that the executive branch is going to enact that with the specificity and the detail that's necessary to make it functional.
Yeah, absolutely. And right, so they've put those in there so that it got, FAA regulation, right? That is something that entire industry is dedicated to. Same with HIPAA, right? Like they are mandated to follow those mandates, or else the fines are quite intense. Now, I would recommend, Gourav, that you lead with the fact that you're a pilot first when you meet somebody, because I'm telling you, I hold you in a completely different regard now. No, but good stuff. Now, we did have a quick question in the chat, and it was in regards to a 16-year-old who recently was arrested via distributed denial of service attacks on the Miami-Dade school. So it looked like there was the FBI and the Secret Service basically pursued him down, and it turned out to be one of their own students. Now, I'm going to guess that's probably criminal, right? They can prove it was him. If the FBI arrests you, most likely it's not going to be civil, correct?
Yeah, so, the students themselves or anyone else who was affected by this may have a civil cause of action. So it's not the government versus the person. It's a person versus a person, or a person versus a company. Those are how civil suits come about. The government is going to say, we're going to, you've heard the term, press charges against you. So we're going to levy criminal charges against you. And then it's the government via person, or the government via company. Like with Enron, it was the government had criminal charges against Enron, and then later criminal charges against the actual board and the executive leadership there. This student is probably going to have criminal charges. I'm sure he's violated a whole host of federal laws. And then if it's found that there are individuals who suffered damage from this, or the school board perhaps, they may turn around and say, okay, we also want to pursue him civilly. Chances are they're not going to pursue a 16-year-old civilly because he probably doesn't have any money, and he probably doesn't have any way to pay those. So it's not going to be a fruitful endeavor for them. But the criminal side, they would certainly move forward with. And absolutely, I think that's the type of thing that any malicious actor is going to be subject to criminal penalties.
So I found the charges, and here's what he was charged with computer use in an attempt to defraud, and it's a 3rd-degree felony. And then interference with an educational institution, which is a 2nd-degree misdemeanor. So those were the two criminal charges that were brought against him.
Yeah, and that sounds right. And they are probably sitting on 50 other charges that they will levy if either those first two or both of them gets dropped, or there's not some sort of a arrangement worked out. Typically, if you have a younger person that does something like that, I imagine that they're going to try to find some way to punish them, but also maybe give them some diversion so they can set an example, but also give them a chance at being reintroduced into society in a functional manner.
Absolutely. Now, bringing it to our next point on the document that we were supposed to touch on was the liability. We really touched on that before as well. But so let's say he was an adult and he didn't just DDoS a school to get out of class, right? He was DDoSing a business and they took financial loss. That's when they could then bring that civil suit and he could be held liable for that.
Correct. Yeah. And there's also other financial implications. There may be fines that are levied under the criminal penalty. A lot of times you'll see those of us that maybe remember the old VCR or DVD or Blu-ray days prior to mass streaming, right? FBI warning, right? 5 years or $250,000 or both, right?
Mm-hmm.
So there could be statutory fines that come along with the crime, and then there's civil penalties, which could be the actual lawsuit and saying, hey, a jury found that you're guilty and you owe these people $1 million, and this is what you owe them. So, and then lastly, if it's punitive, they may say, it's $1 million fine, but we really think that you deserve more punishment than that. So we're going to up it to $3 million because we really think that there's a punishment aspect of this fine that needs to be in place.
And that makes absolute sense. Now, I'm going to pivot real quick, Brandon, but then I want you to touch on the prudent man rule, if that's okay. Now, that's against the criminal, but what if that organization didn't perform due diligence or due care in protecting their data, and then they were held with a HIPAA violation, right? So now we're pivoting back to the organization itself. How could they be held liable, Brandon? And when you're talking about the prudent man rule, where does that come into play?
So from what I've been reading here, is that the management must follow the prudent. Now I'm suspecting this is kind of all CISO, executives, kind of that must follow the prudent man rule that requires officers to perform duties with diligence and care that ordinary, prudent people would exercise under similar circumstances. The officers must exercise due care or reasonable care to carry out their responsibilities to the organization. So I think that's really important to address, because you have to have that mindset. Now, Gourav, what do you think about that? Like, in our day and age where, you're looking at all the security protocols, the practices, when we look at the prudent man, how important that is for CISOs and executives to really know that?
I think it's important to understand, and that same term, prudent man, is also referred to as reasonable person. There's this mythical person that is the most reasonable of all people, that is basically supposed to make a decision in a reasonable way, and it's a very nebulous concept. But really, I think the crux of it is to understand that if a group of people were to look at your action or your inaction, and they were to look at it and say, we really do think that that's something they should have done, or that's something that they really ought to have put some thought into and thought of, chances are that you're going to find that the prudent man or the reasonable person is going to find that too. And so example would be, things that we find are common knowledge in the security industry, using a simple password. Well, you know what? There may not be a specific law that says you have to use a strong password, but you know what? A reasonable person or a prudent man would have done that.
Right. Okay.
Now, I do have to ask, because, and we talked about it a little before, but what about new technologies, right? So if somebody's switching over to cloud, and we touched on it, no, you can't leave your S3 bucket open to the public, and it's not encrypted on top of it. Like, at what point do new technologies kind of cross that line? And now any normal citizen would have done that. Does that make sense? Did I explain that well?
Yeah. So I think what you're asking is really, if you have security experts like the people presumably on here that are going for their CISSP, and they may understand something, but at what point does your non-IT professional at what point are they held to the same standard? And so the answer is really it depends, which I know is a gray answer that doesn't answer anybody's question. But if you have a certification, if you have a degree, if you are a professional in a certain industry, that standard shifts, and it shifts based on your knowledge and expertise. So an example would be, I am a CISSP. I might be held to a standard that says, hey, you know what? We think that there's going to be punitive damages because you had a simple password and 1,000 people lost their information because of you, and you should have known better, and you're well educated and you understand that. if you take a person that is, let's say, a farmer or a sanitary worker or something along those lines that doesn't work in the industry, and they don't make that same decision, and 1,000 people lose their information, or even a healthcare worker that hasn't been trained on HIPAA. That's why they have these annual trainings, so they can say, you should have been a prudent person, right? They turn around and say, the standard of care is going to be different based on your certifications and your understanding of the material. It's not entirely prescriptive. It's very subjective.
Wow. Now, Dr. Tony has a question in the group. What if the organization is providing critical life services? Can a hacker be processed for murder? Example, ransomware attack on a hospital taking life support service offline, resulting in death of one or more persons.
So I'm not going to tell you that I know of any instances specifically where someone has been convicted of murder or has been charged with murder for those things. I can't think of an example off the top of my head, but what I can tell you is that the standard for murder, and again, I don't want to get into too many nuances, but there's common law murder and then there's statutory murder, but they require something called, and I'm going to go Latin on you for just a second, it's called mens rea. It's the state of mind of the individual. So did they have the intent to kill people, or was it just recklessness? Meaning, did they DDoS the hospital and someone died and it was complete recklessness with no, again, this reasonable person standard? Would a reasonable person have thought that somebody could lose their life in that situation, right? And so if the answer is yes, they might be convicted or at least tried for murder. If not, you may turn around and say, they were just picking a random IP. They had no idea that it was a hospital. They had no information about it, and they were trying out some script as a script kiddie. And here you go. Maybe they would be charged with manslaughter instead because they didn't really know they were going to kill somebody. A reasonable person, not knowing where that IP went, didn't do any due diligence, didn't do any research. So they might be charged with manslaughter instead of murder.
Well, and so she followed up this question, Gourav, with an interesting one. She pivoted it back towards the enterprise itself. Now, if someone at the hospital, such as the CISO of the hospital, can they be found negligent, if the right security controls were not in place to prevent a ransomware attack?
So there's absolutely an opportunity for negligence, especially on a civil side. If there is a written standard to which you are required to adhere, like HIPAA, and you don't meet the requirements of HIPAA, then there's going to be a whole lot of other piece of information. Did they have actual knowledge, right? Did they know that the security protocols weren't in place to prevent this type of an attack? Or should they have known? Again, back to this reasonable person. So you're going to determine whether the person was negligent, whether they were grossly negligent. It might be something where a reasonable CISO might not have known. They might not have known because a user did something without their knowledge, and they still thought the organization was compliant. So I think there's a lot of factual aspects there that would come into play. But certainly, I think they could be charged at least with some form of criminal negligence.
Wow.
Now, we had a comment real quick from Jesse Carollo, and he said he would compare that situation to arson charges. And I believe if you're a volunteer firefighter or a firefighter, thank you for your service. But he said when a firefighter got hurt in an arson fire, the arsonist who started the fire was actually charged with every injury or illness that was incurred as a result of the intentionally set fire. Now, I know right now in California, I think it's California, Arizona, somebody did a baby reveal, and it's a massive wildfire. I think they can also be held, I don't know if they could be held liable for an accidental fire in regards to every injury or illness, but there will definitely be a civil case that comes back around for them.
Yeah, I think you'll see lawsuits on those type of things. And again, the idea of the criminal justice system is to make sure that people are held accountable for actions. And one of the key components of that is what was the intent of the actor, right? Was it their intention to set the fire like an arsonist? If their intention was to set it, then absolutely. There's a doctrine called felony murder, which means if someone dies while you're intentionally committing a felony, then that is murder. Even though you didn't intend to kill them, you were in the commission of a crime, and therefore they died as a result of you committing that crime, right? So you smashed a window to burglarize something, and it just so happens that because you broke the window, the glass flew across the room, hit somebody, they died. You didn't mean to kill them. In the commission of a felony, you're now going to be held to the murder standard because you were committing a crime at the time. So again, it's the intent of the person. That's a really big piece of the criminal aspects.
Well, and that comes back to the investigation, right? So Brandon's kicking us off. I think he's responding in the chat real quick, but he's going to kick us off on this next part, because in order to be held accountable for smashing the window, etc., like there has to be evidence, right? And this is one of the most important legal concepts for InfoSec professionals to understand.
No, yeah. One thing before I jump into that, talking about this, Dr. Tony was talking about the hospitals. I remember HP came out with the Wolf series, right? And they were showing how the Wolf, right, the actor Christian Slater, was actually hacking a CEO or an executive and compromised his prescription, and kind of went through that and that whole series of how that happened. So we're kind of talking about both sides of the coin here, of the legal aspects, but also looking at the technology and how it actually can come through that. You know, they were hacking a printer and kind of walking through that process, and they were able to change the prescription, the time, and the dosages and all that. So as we're talking about here about like the HIPAA and the medical information, it's, I mean, all this stuff is pretty prevalent that security guys have to be aware of and understand both sides of how to protect documentation, legal, HIPAA, but also the, you know, to prevent from the actual compromise itself. So I think that comes into due care and due diligence, as well as understanding it inside and out. So let's go into the investigations, legal aspects of investigations. Investigations are a critical way in which information security professionals come into contact with the law. Forensics and incident response personnel often conduct investigations, and both need to have a basic understanding of legal matters to ensure the legal merits of the investigation are not unintentionally tarnished as it relates to with search and seizure. So now I know you guys were talking about earlier about forensics and, you know, chain of custody and all that. I think that's really important to, you know, as we're going through this, to really think about how you deal with and how you respond. I know when I worked for the Ontario government, we had an incident response process of, you know, it was almost like check, like you kind of did this first, this second, notifications, alerts, like all that. So it's interesting, like, you know, when the CISSP, you have to really kind of think of the process too.
Yeah, absolutely. Now, there, you know, of course there's the process, but first and foremost, the evidence has to be relevant, authentic, accurate, complete, and convincing. And for those of you going for this exam, I'm pretty sure you'll probably see something like this on here, right? What are the things that evidence should be? Once again, relevant, authentic, accurate, complete, and convincing. And when you're gathering evidence, you should keep that in mind for what you should present. Now, there's a couple different kinds of evidence, as we've touched on. Real evidence is going to be the first one that we touch on. So this is the first, most basic category of evidence. It's real evidence. It could be something like a knife, a bloody glove, fingerprints. However, with most computer incidents, real evidence is commonly made up of physical objects, such as hard drives, DVDs, Blu-rays. I don't think I could put that there, but storage devices or business records. So that the physical objects themselves in a, you know, the PC, the server itself, that's the real evidence.
Right. And then we go into direct evidence, which is testimony provided by a witness regarding what the witness actually experienced with their five senses. The witness must be experienced what they are testifying to, rather than have gained the knowledge indirectly through another person, hearsay. Now, this is kind of funny, hearsay. You always hear this in the legal shows, right? And you're watching that, and it's, oh, that's hearsay, right? And it's, you always hear, like I was watching Suits, and you heard that earlier when I was we were getting set up. I was watching Suits. Well, a lot of times you hear that they're talking about hearsay. So it's kind of interesting, like, you know, it has to be directly from that person, that individual that heard it.
Yep. And then,
yeah, so hearsay is one of those interesting and very nuanced topics within the legal field, and this is going to go back a ways, but I want to say there's 49 different kinds, if I remember the number correctly, of hearsay. and they're basically exceptions to a rule. And the idea, one of the most critical pieces is just remember direct versus indirect. So direct means I saw Joel break that lock or pick that lock, versus I heard from Sue that Sue saw is going to go Joel break into that room or break that lock. My testimony on what Sue saw is hearsay. Sue's testimony is direct evidence.
Right.
And it holds a now hearsay can be part of evidence, but it holds a different weight, correct?
Yeah. So really, the aspect you're talking about is convincing, and you were talking about the sort of 5 elements of what evidence should be. And one of the things to understand is that there are kinds of hearsay that are exempt from this rule. So you could have a record that is kept in the ordinary course of business, right? This might be a third-party account. It may not be direct evidence. I have a driver that is logging information. I have a janitor that goes into a server room, and every day, twice a day, when he goes into the server room, he signs in and he signs out, right? If the janitor's not available, but we have his sign in and sign out sheet, that's not his direct testimony. However, we can get that admitted, even though it's a record of his coming and going from the room. It's an acceptable record because it's kept in the ordinary course of business. So that's just one example of the different hearsay exceptions that are out there. And like I said, there's more than I can remember. I'd have to go look them all up for you, and you would probably fall asleep. So. Yep.
But you touched on a really important fact for the cybersecurity professionals. I know in defensive cybersecurity, we try to log everything, right? So if those logs in your SIM are part of regular business process, that can be submitted as evidence as hearsay, right? So that's a great reason why you should log everything.
So now here's an interesting point Dr. Tony brought in. I have noted in research that in some cases, companies may opt not to implement optional security framework, as going through the process may reveal controls that are needed, and if they do not take action to subsequently implement controls and later breach, that then there would be discovery evidence potentially providing negligence, sort of the ignorance of bliss kind of mindset. So from my understanding of that, what they're doing, and correct me if I'm wrong, Dr. Tony, is that, if there's controls or measures that are not being implemented, they'll just kind of ignore them right now, because if they get caught, that they knew about them, now there's negligence, right? If they knew that the controls, they document that these controls were supposed to be implemented, but they didn't do them, now there's negligence. So interesting.
Yeah, no, it is. And that's a great point. One of the most common responses that I get when an individual on board of directors reaches out to us and says, "Hey, we'd like you to come in and perform a risk assessment for us." One of the most common questions I get is, first, if we find a risk and then we don't do anything about it, now that's a business record that we have, and somebody can come back and say, "Oh, well, you knew about this, right? So you had actual knowledge that your firewall was out of date, or you had actual knowledge that these systems weren't secure." And now they have that duty, or that duty of care, to go in and actually perform the remediation for this. So if you know about it, you have to do something about it. One of the things that companies will do is they will actually reach out to an attorney and they'll say, "Hey, we would like to perform this risk assessment." And there's key phrases there, but privileged and confidential. We want to do it under an attorney. And the reason we want to do it under an attorney is it's in anticipation of litigation. And what that means is that we're expecting a lawsuit. This is going to be protected by attorney-client privilege, so the other side can't get a copy of that risk assessment without going back and forth and having a real fight over it.
Yeah, it makes sense.
I've been doing risk assessments for a long time, Gourav, and that's the first time I've ever heard of someone doing that, and it makes absolute sense, because if you just go through any third party to do your pen test and it's not part of attorney-client privilege, man, you can get a copy of that no problem.
Exactly. Yep. You request it and you get it. Whereas if it's done under their attorney, it's privileged and confidential, and it's much harder to get access to that. I will tell you a real funny anecdote. I have a client that experienced a ransomware attack a few months back, and I said, hey, I think we should bring in a forensics investigator to handle reviewing what's going on here. And their director of IT said, no, we're good. We're experienced. We've got it in house. I said, hey, okay, here's what I need. I need a forensic snapshot of the hard drive in the computer that was affected by ransomware. That specifically was a server in a closet. And so about 3 hours later, I get an email back saying, yep, forensic snapshot's complete. See attached. They literally sent me a picture, like a photograph of the hard drive. And for any of you that are in the cybersecurity field, you'll get a kick out of that. So I just thought I would share that with you. Obviously, I can't tell you who the client is, but we had a much more in-depth conversation about who should be performing the forensics, and needless to say, they brought someone in.
That's awesome.
Oh, can you can't even prosecute that guy for not doing due diligence at that point. He didn't even know. Oh.
No, he just took a picture and he goes, hey, forensic snapshot complete. I drove out there and I took a picture of it. Here you go. I was like, okay. I should have been more clear.
Now, okay, so you talked about memory images, right, and snapshots of disks. So it's interesting because there was a rule 802 that permitted admissibility of records for certain reports, but there's another rule named 1001 that also, when it was interpreted, allows for disks and those memory images to be admissible. So that's Rule 1001. So anybody looking to go for the CISSP, Rule 1001 has to do with disk and memory images and allowing those to be permissible as hearsay in court. Now, real quick, it states, I'll just complete that thought, but it states, if data are stored in a computer or similar device, any printout or other output readable by sight shown to reflect the data accurately is original. Now, this definition has been interpreted to allow for both the forensic reports as well as those images we talked about before.
Except for the cameras.
Except for the cameras.
That Gourav got, the one that Gourav got.
Right, exactly. That is not the kind of forensic snapshot you want.
Doesn't count. Now, it looks like the best evidence rule. So courts are going to prefer the best evidence you have possible, right? Original documents are preferred over copies. Conclusive, tangible objects are preferred over oral testimonies. And then once again, it comes back to those 5 criteria, right? Is it relevant? Is it authentic, accurate, complete, and convincing? And the best evidence rule, it's going to prefer evidence that meets all of those criteria over just a couple. So. Awesome. Brandon, I know I skipped ahead a little bit. Did I miss on anything? I think we need to go back and just touch on collaborative evidence, if that's okay.
Well, you had direct evidence, circumstantial evidence. Mm-hmm. Circumstantial evidence is the evidence which serves to establish the circumstances related to particular points or even other evidence. This type of evidence offers indirect proof or typically cannot be used as the sole evidence in a case. For instance, if a person testifies that the direct witness, the defendant created and distributed malware, this would be constitute direct evidence. If a forensic investigation of a defendant computer reveals the existence of the source code for the malware, this would be constitute of circumstantial evidence. So have you ever ran into that, Gourav, yourself? Direct evidence, circumstantial evidence?
So I've run into other attorneys. That's circumstantial. I said, you saw that on TV. And the reality is that it's not as cut and dry in the courtroom. Typically, you want to establish. So you may. It really depends on what the other party is contesting, right? So if I say, hey, this is your hard drive, okay, and they go, well, no, we're not going to admit that that's our hard drive. You need to prove that it's our hard drive. Okay, well, so I may have the evidence that's on the hard drive, but I need to prove that it's theirs. And in order to do that, I may need some circumstantial evidence. So I may need something that says, hey, here's a video of you walking in and out of the server room holding this hard drive. Well, Okay, well, how do you know it's that hard drive? Well, we've got a 4K camera, and I zoomed in, and here's the serial number, right? So, or this is the time that it occurred, or we can see that along with a log of from the server showing that the hard drive was removed at the same time as the picture on the camera showing you walking out. Okay, now we have enough information to place you at that place at that time, and therefore, in all likelihood, that is your hard drive. So the idea is helping take direct evidence and establish that it is in fact at the time and the place that we're saying it was.
So we have the hard drive, which is the direct evidence. We have the circumstantial evidence, which is the camera watching you be the only person go into the closet. And then we have corroborative evidence of the log of you going through that physical door. Right? So the corroborative evidence is going to strengthen your circumstantial or direct evidence, correct?
Yeah, so each of these, obviously direct evidence is the strongest. Then you have circumstantial, corroborative evidence. And then lastly, hearsay, unless it falls under one of the many hearsay exemptions. And those are, obviously anytime you can have direct evidence, it's going to be more compelling to a person than hearsay.
Absolutely. Now, once you have this evidence, then we drop into evidence integrity. And we're sitting at about 7:46 left. So I want to let anybody know if you guys have any more questions, get them in the chat quick so we can get them answered for you today. We will be stopping right at 8 this afternoon. But let's jump into evidence integrity. So the evidence we get, whether it's direct, circumstantial, corroborative, it must be reliable, right? And it's common during these forensic or incident response investigations to have to analyze this digital media. Now, if somebody can analyze it and prove that it may have been tampered with, it basically can be dismissible in court. So in order to maintain the integrity of this data, you have to maintain it throughout the entire course of the investigation or analysis. Now, checksums help, right? So if you have a SHA-1 or an MD5, you can take a quick checksum of a device, and then when you present the evidence, you can take another checksum to prove that from the time that you touch the data to the current time, it has not been tampered with. Now, if you for anybody not familiar with checksums, if even one bit has been changed, that hash is going to be completely different. So it can prove that, basically collisions and checksums are basically impossible. Google's done it a couple times, but without a doubt that those are the same, it has not been tampered with whatsoever.
Yeah, so chain of custody is important. This goes back to your convincing. I will tell you that chain of custody is not necessarily a legal requirement in all jurisdictions. So there may not be a law that says you must maintain chain of custody. What happens is if you don't have chain of custody, then someone on the opposing side can use any gaps in the chain of custody and say, hey, look, they had an opportunity to change this information. It's missing a signature here where it was transported from point A to point B. Someone could have swapped the information on the way from the incident site to the forensics lab before they took the image if they didn't take it on site, so on. So it weakens your position. It doesn't mean that by violating or breaking or not having a complete chain of custody that the evidence will be completely inadmissible in court. It just means that it goes to that convincing factor, which is one of the 5 core tenets that Joel talked about. And it's more convincing if you have a chain of custody. It doesn't mean that it can't be admitted if you don't.
Absolutely. Now, I do want to talk. I want to, and thank you for that. That was perfect because in all the movies and shows, you hear chain of custody, and if it's broken, it's like your case is getting thrown out of the court, right? And that's
get away with murder,
right. But so when we're talking about those checksums, real quick, we were talking about this before the show, but I was doing mobile forensics for a little bit. And the problem with doing a checksum on a IoT device or a mobile device is as soon as it connects to a network, your checksum will change. So what you're required to do is put it in a Faraday bag. So quick pop quiz for anybody here, including you two gentlemen. You guys have a device in your home that will block all frequencies out of an IoT device or cell phone. What is it?
Faraday cage.
Faraday cage, but what would a normal person have? An actual device in your home besides a Faraday cage?
Microwave.
Microwave, got it, right? So if you throw a device in the microwave, you close it, none of those. All right. Don't turn it on, please. You'll get some fireworks. But it actually acts like a Faraday cage, so you can block those network connections. So not sure if you'll ever use that at the office, but if you need a Faraday cage, you can use a microwave until somebody else can arrive with one.
Yeah, and you may also have the days of people putting cards in their own computer are not as frequent, but you may have old bags. They'll look like static bags or anti-static bags, and some of those can act as a Faraday cage as well. So those may be used as well if you need to preserve something.
Very cool. Yeah, I think most of the ones that I've seen aren't the clear ones, right? They're the black ones that will act. Once again, you'd have to check, but
Right.
cool. Brandon, you want to take reasonable searches, or you want me to jump in?
Where are we here? Chain of custody. And then I know one thing we've seen is a chain of custody bag. We took a screenshot of that, and it has and then we just wanted to talk about this. Like, it has all the information you're supposed to document to, date, time, location, case number. Like, of course, I think this is more for the police, but it has as much information as you can document. I know for myself, when I was working physical security, when we had to do chain of custody and any documentation, that it had to be date, timestamp, location, potential weather. Like, you had to document as much as you can on these. So just make sure as you're doing, your chain of custody, make sure you know what information has to be documented.
That's it.
And now, we're looking at reasonable search. So the Fourth Amendment to the United States Constitution protects citizens from unreasonable search and seizure by the government. In all cases involve seizure evidence. If a court determines the evidence was obtained legally or illegally, then it will be inadmissible in court. So now it's funny. We hear about a lot of this in the United States. I'm in Canada. If they have, just cause, we can be searched, right? So it's kind of different from Canada to the United States.
Now, Gourav, can you speak to that at all?
Yeah.
Yeah. So we don't have enough time for me to speak about reasonable searches, but I'll give you the quickest version, which is and this applies to a lot of different types of searches, not just a search for your computer hard drives. It could be a physical search. So typically, there's certain levels or thresholds that have to be met. One of them is probably the loosest standard, which is called articulable reasonable suspicion, ARS, and that's something where you're walking down the street and a police officer. This is a very hot topic right now. A police officer looks at you and they have to be able to articulate what their reasonable suspicion is about you, and then they can perform what's called like a stop and frisk, and they can say, hey, I have a reasonable suspicion, might be in a vehicle, walking, etc. I have a reasonable suspicion, and so now I'm going to go to the next step, which is I'm going to do some cursory overview of what you have. It doesn't mean I can look inside of things. It doesn't mean I can look inside of your phone. I can't open up your phone. I can ask you anything I want, but you don't have to do it. Then the next step is okay, I've now found something. When I did the stop and frisk, I found something. So there's probable cause, and that's where you start getting into charges. So from probable cause, now I can detain you and perform a more in-depth search. So as this applies to security, it also applies to every other person walking down the street. And so once you have probable cause, now you have a higher level, higher standard of suspicion. You can turn around and start doing more investigative work. From there, a lot of times they'll say, hey, we're going to stop. We're not going to just conduct the search. We're going to go to a judge with our probable cause. We're going to ask them to validate our probable cause and give us a warrant that authorizes us to do that search. And the reason they'd want a warrant as opposed to just saying, hey, I'm here right now. Maybe if I think the evidence is going to destroy it, I might not want a warrant. I don't want to wait. But if not, I'm going to wait and get the warrant, because now I know a judge has reviewed it and I know that they agree with my probable cause for the search. And then when you have the warrant, if it's later found that the probable cause was insufficient or invalid, the warrant may have been invalid, then the search is invalid. And there's a doctrine called the fruit of the poisonous tree. And what this means is that any piece of evidence that was derived from this search is going to be inadmissible. So let's say I get a warrant or even I search a person and I find a USB stick, and that happens to have national secret data on it, and we want to charge them with a crime, and then we find out they didn't have probable cause, it wasn't sufficient, or they didn't have the search warrant was invalid for some reason. We still have confiscated that material, but we may not be able to charge them with the crime because anything else that was found on them, even if they had drugs in their other pocket that had nothing to do with why you were searching. You're searching for this USB. You found drugs. You found a bloody knife. You found all of these other things in their other pocket. If the search was invalid, all of that evidence becomes inadmissible. So it's called the fruit of the poisonous tree.
I don't know if I could be a judge for that reason. Like, how do you not have a bias when it was found on the person, and then you realize they didn't have the right to search and seize, and then it's inadmissible? Like, I don't know how you could overcome that. It's got to be difficult.
I'm sure it's a challenging decision for them.
That's true. Now, real quick, we could talk about the color of the law, but I'd rather go into entrapment and enticement with our last few minutes, if that's okay. Brandon, do you want to jump into that?
Yeah, let's go on to that, because there's the last two sections. There's entrapment, enticement, then we got computer crime. So entrapment is when law enforcement or an agent of law enforcement pursues someone to commit a crime when the person otherwise had no intention to commit a crime. Entrapment can serve as a legal defense in a court of law and therefore should be avoided if prosecution is a goal. Closely related, a concept is enticement. Enticement could still involve agents of law enforcement making the conditions for commission of a crime favorable, but the difference is the person is determined to already have broken a law or is intent on doing so. So what do you think about that, Gourav?
So really intent driven?
Yeah, it is going to be intent driven. So you're going to be stuck with we call it the but-for standard, right? So what that means is, but for this happening, would the person have committed the crime, right? So you're going to turn around and say, all right, here's a person. If I'm a officer of the law and I walk up and say, here's $100 to go hit this person, right? I want you to go over and punch them. Here's $100. Or go over and steal this hard drive. Here's $100. That's going to be entrapment or enticement. If I say, all right, the person is, I think, going to go steal this hard drive, or this person is going to hit this other person, and I happen to make the circumstances right, meaning I leave the door unlocked for them to go in, or I distract the other person so they're facing the right way so that they can be hit. Now I'm not, in fact, entrapping them, because I'm not promoting them to do it. And by me leaving the door unlocked, by me making the person available to be hit, you have to ask yourself, but for the actions of the law enforcement officer, would this person have still committed the crime? And if the answer is no, they wouldn't have committed the crime anyway, then that leaves you with the distinction between entrapment versus non-entrapment, which is just making the circumstances right for them to do a crime they would have committed anyway.
Oh, wow.
And as soon as is a judge able to determine that as entrapment on his own, or is that something a jury would help decide?
So typically, there's a lot of nuances there. Typically, you're going to have a prosecutor that is going to prosecute something. You're going to have a defense attorney that's going to raise the argument for entrapment. They're both going to present evidence about the entrapment, and he's going to use his defense to those charges. And then a judge would typically dismiss the charges, or in other ways level the playing field.
Now, Dr. Tony has a question here. Could you get to a form of entrapment from taking offensive cybersecurity measures?
From taking offensive cybersecurity measures. I don't know. I don't know if I quite understand the question, but I'm going to try to guess at what Dr. Tony's asking. If you are, and this is sort of like a counter-strike position. If you're being attacked and then you counter-strike the attacker or the bad actor, I suppose you could be in that position. So like if the federal government or another agent of law enforcement is attacking you to entice you to attack back, perhaps that could be an entrapment situation if they know that you're going to do that type of behavior.
But from what I've seen, the government is the only one who should be taking offensive cybersecurity measures. And I think it would be a really hard argument, and this is just coming, once again, not from a legal background, but I still think it would be a really hard argument to say you entrapped me to be, to attack. I mean, offensive cyber is very, I'm going to say cut and dry. You're either defending or attacking, right? So
it is for people objectively looking at it, but sometimes in the moment people may
feel that way. Right?
Yeah, they may feel like they want to do something offensively back.
Well, so that kind of leads us into our final topic. Now, I did want to touch on Tim's. So Timothy Lesnick had a comment. He said, "Should I leave my phone in the microwave when I go to sleep so they don't find me?"
Right.
So Tim's actually Gourav's business partner. So.
I saw that, but I had to throw it out there. So thanks, Tim, for that. And yep, feel free to do that every single night, please. And
take a picture. Take a picture and send it to us.
That's right.
Right.
Cool. So final point is computer crime. 3 types of computer crimes. We have computer systems as targets. So you're targeting the computer system. Computer systems as a tool to perpetuate a crime, or computer systems involved but incidental. Now, there are 2 main ones, right, that are more significant. It's computer system as a target. So crimes where the computer systems serve as a primary target. A, disrupting online e-commerce by means of distributed denial of service, or installing malware on systems so that the computer system is the target itself. And then computer as a tool. So where crimes where the computer is a central component enabling the commission of a crime. A couple examples include stealing trade secrets by compromising a database server. So the actual crime wasn't hacking the server, it was actually stealing data off the server, such as an insider threat scenario. The crime may not have been I had access to the data, it was I took it off the system and tried to head to China with it. Another one is conducting computer-based reconnaissance to target an individual for information disclosure or espionage, maybe a hacktivist type attack there. So, Gourav, real quick, what are you seeing more of, computer as a tool or computer systems as a target?
So from my clients' perspectives, typically, we're defensive cybersecurity, which is where we should be. We see that, the crimes are generally a outside third-party threat actor that's trying to gain access to a system that has information on it. They happen to be using a tool to perpetuate a crime. They're using their system or their access to a botnet, et cetera. And I think, it really gets to be a very blurred line because most of the time, as you know, when you get into a system as a pen tester, you're going to pivot, right? So all of a sudden you're using someone else's asset against them. So their own asset is being used against them. And so then is their computer the target? Is it the tool? Or is it the system that happens to have the data? And it could be all of the 3 at any given moment. So, I think that's an area where the lines get blurred very quickly, but all 3 are very, very prevalent scenarios.
I could absolutely see where those lines get very, very blurred. So thank you so much once again for joining us, Gourav. I am posting his LinkedIn profile here in the live chat. So please, 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 if you joined us a little later, click on his link, add him as a connection. He's CISSP certified. He's a barred attorney in Florida, and he is a fantastic resource, as you've seen here this evening. So Gourav, thank you so much for joining us.
Thank you.
I'm happy to help. Anybody reach out to me if you have questions while you're studying. If I can answer them, I'll do my best.
That's it.
Awesome.
Brandon, thank you, buddy.
Oh, Joel, now just before we go, just to help Dr. Tony out here, I do not recommend companies take offensive measures, by the way. So the question was, because trying to understand, but she just recommends, I wanted to throw that out there so someone else watching this doesn't think she's an offensive attacker and going out,
That's a conversation for another day, right? The hack back. So maybe we'll have you back for that, Gourav. Who knows?
Absolutely. Happy to do it.
Awesome, guys. Signing out. This was episode 4 of the Cyber Incision live stream. Thanks so much, guys. Have a wonderful evening, everyone.
Take care.